All right, well, we all love a police pursuit on television and watching the bad guys get busted, but what happens when an innocent person is hurt or worse in one of these high-speed pursuits? So I want to talk about what Georgia law provides, and while we're on that subject, this kind of thing happens more often than you might think. A recent investigation by the Atlanta Journal-Constitution found that Georgia has one of the highest fatality rates in police pursuits in the entire country. And we're talking about, not just the suspects, but innocent people. So in Georgia, you, first of all, if you're the suspect, you can't sue the police for, what we're about to talk about. So if you're one of these people fleeing from the cops, you're just an idiot. And I'm sorry, but let's just call it what it is. You're putting innocent people in harm's way, and you deserve to go to jail. But if you're an innocent person who's been hurt by one of these clowns, well, you have a remedy, but there are limited circumstances under which you can pursue the law enforcement officer. Of course, you can always sue the suspect, but you're dealing with criminals, and they may not have insurance, or usually there's not going to be much to go after, let's say, when you have a criminal who's running from the cops. But when there are certain circumstances, again, where the law enforcement can be liable. So you have a few issues to look at, but one I want to talk about is this code section 40-6-6 of the official code of Georgia. And this essentially is the standard for when a law enforcement officer can be liable for pursuing a fleeing suspect. And what this code section tells us is that the officer's pursuit can only be what we call a proximate cause of the injury if the officer acted with, quote, reckless disregard for proper law enforcement procedures in the officer's decision to initiate or continue the pursuit. And if that's going to be a fact question that a jury would have to decide ultimately, but if the jury were to conclude that the officer did in fact act with reckless disregard for proper law enforcement procedures, then the jury can then find that reckless disregard caused the injury. So it's not enough just to show that the officer recklessly disregarded law enforcement procedures. The jury would actually have to also conclude that reckless disregard approximately caused the injury. But if you can't show that reckless disregard, then you cannot hold the law enforcement officer liable. There are also issues of governmental immunity to deal with in these types of cases, which is a bit long to go into in this video, but essentially when you have a county or city law enforcement officer, they will have immunity, but the immunity is waived by statute, and the amount is provided by statute, but more often than not, it's determined by the applicable insurance policy. So the statute says that the immunity is waived up to the extent of insurance. So if the county or city has purchased a liability insurance policy that provides for $500,000 in coverage or $1 million in coverage, then that's going to be the limit for the law enforcement officer's liability. But of course, you still would need to show that the reckless disregard exists and prove proximate causation. So let's talk about that. How do you prove that the officer recklessly disregarded proper law enforcement procedures? What are proper law enforcement procedures? Well, there are essentially industry-wide standards, and you can there's experts that have testified countless times to juries about this sort of thing, and are experts on proper law enforcement procedures. And that's one way, is through expert testimony to show that this is not, this was a reckless disregard. They can't say quite that because that's a legal question, but they can say these are the procedures and this is what the officer did, and in my opinion, that this is not in keeping with proper procedures, and the jury can decide whether that was a reckless disregard. More often than not, you're also going to have a set of written procedures, and most departments have essentially a list of factors that the officer has to consider in determining whether to initiate or continue the pursuit. And that's another issue to look at is, when the pursuit initially started, there may have been good reason to do so, but things can escalate, and let's say the pursuit starts off and things may not be that bad, the person's not going that fast, but then they go into a very populated area and reach much higher speeds. People are being put in needless danger, et cetera. Then the officer should call the pursuit off. So there are different ways that an officer can be found to have acted with reckless disregard, but ultimately it is a factual question that a jury is going to have to resolve. So if you can get past immunity and you can show a policy violation, essentially, or show reckless disregard, then a law enforcement officer can be held liable for causing injury in one of these pursuits.